Perkins versus Perkins.
Well, before we get started, I am going to reserve court costs against both of you for $500 because I have warned you many motions ago, March, April, June, August. I'm not going to keep going through this. So I don't want your money right now, but I want you to think very highly of it, because if I get any more of this stuff, then one of you is going to pay the 500, because I'm not going to keep doing this. This is ridiculous. And I would have thought that the parties would have picked up. I'm not a particularly complicated person to read. Both of you should either you both have terrible social skills, or you both should have picked up on that a long time ago, that I'm not going to continue motion after motion after motion. Some people don't file one motion in 18 years. You people have filed, this is 1, 2, 3, 4, 5 of them since March. And that's unacceptable, and it's an abuse of the process. And the next go around, if I get this thing back, $500 a piece, okay? Because now it's going to start costing people money. Now, here's what I see, and maybe correct me if I'm wrong. Once again, we're here because there are 2 stipulations, and neither one of you thinks the other should sign it. Is that what I'm seeing?
No, sir. We had an agreement, and when he went to court, he changed it. He refused to speak to me about it, and I attempted several times. And when he did, he had changed our agreement. I can't be asked to agree to something that he changed last minute. That's unacceptable.
No, what's unacceptable is me having to pop in and figure out these things all the time. That's unacceptable.
I agree.
So
I agree.
And you're not listening to what I said. There are 2 proposed stipulations. One looks like it was written by you, and the other one looks like it was written by him. And the question becomes is, which one of these am I going to sign? That's really what it all comes down to. Right?
Yes, sir. You've read my response, and I hope that you see that I made every attempt to work this out with him. He refused to speak to me about the issue, and then changed what we had agreed on last minute.
What did he change?
The birthdays.
Okay, what about the birthdays?
That we had agreed that we would both be allowed to spend time with the children and have option to spend time with the children on their birthdays. That is most important to them, because I've never missed a birthday. Not voluntarily or otherwise.
Well, so it's every other birthday. Okay.
Right.
Is that the only issue?
There should be. That was the only issue. And we agreed when we left court last time that we would both have option to spend time with them for their birthday.
Mr. Perkins.
And then, like I said, he waited until the very last day and changed that.
Mr. Perkins, what's going on?
Yes, sir. When last time we were in court in front of you, I was at the courthouse. I picked up the stipulation paper for her. I wrote exactly what she wanted on it, and she refused to agree to it.
Sir, I sent you screenshots of that. That is not true.
I wrote exactly what she said.
See, here's what we're going to do. I'm going to put you on mute, and I'm going to put you on mute, because if you think I'm going to listen to the Hatfields and McCoys, you can shake your heads all you want. I don't care, because I've already figured this situation out. So if the parties want to spend some money, they can, but there's absolutely no reason why the parties cannot spend equal amount of time on the children's birthdays. And the fact that I have to tell both of you that is outrageous in my view. So I'm going to sign the stipulation that looks like anyway. It's been prepared by the defendant that allows for 2 to 3 hours on the birthdays. I'm also going to add in that the court is sanctioning both parties $500 suspended. That means I don't want your money right now. I want this problem solved. Okay. And that's going to be the end of it. So I'm signing this one today with the addition of court costs reserved against both parties. And maybe, just maybe, that will straighten things out. But I am not kidding anymore. This has to be, these are parental decisions, and they have to be straightened out by you two. So I'll sign it, and you'll be getting it in the mail. And I hope things from this point forward work out better for both of you. You can both sign off. We're adjourned. It looks like I have competing motions, which is always interesting. The first motion is by Ms. Wheeler, and that's relief from judgment. Did you get a copy of that, Mr. Wheeler?
Yes, I did. I actually filed a reply too.
Okay. When did you file that?
It was the day after I received it. So it was,
Oh, I got it. Yeah, I do have it.
Yep.
Got it right here. Then you have also filed a motion relative to parenting time. Ms. Wheeler, did you get a copy of that?
I did.
Okay. Let's start with Ms. Wheeler's first. Motion for relief from judgment. Let me tell you what I know. On August 6th of this year, there was a pro confesso hearing scheduled, but it was adjourned until September 16 of 2025 with referee Kessler. The judgment of divorce was signed by referee Kessler on September 16 of 2025. Along with that is also a referee statement, which tells the parties there's a what's called 21-day objection period. When the judge did not receive any objections, the judge signed it, the judgment, which included all the addendums. So I guess my question to you, Mr. Wheeler, and I think you answered that in your response. You prepared a proof of service on August 20th that says you sent a copy of the proposed judgment to Ms. Wheeler. Is that true?
Yes, the only thing that changed between the two things was the parenting time agreement. That was the only change that was there.
Okay. But included all the addendums.
Correct.
Okay. So Michigan Court Rule 2.612 allows relief from judgment for such things as mistake, inadvertence, surprise, excusable neglect, or fraud. So I guess my question first, Ms. Wheeler, why didn't you object to any of this stuff going on?
I don't understand. I didn't have any of that information. None of that was sent to me from the last court hearing. I didn't get any of that paperwork.
Oh, because he, Mr. Wheeler signed a verified proof of service that it was in fact sent to you. Did that come back in the mail, Mr. Wheeler?
No, that one did not come back. Are we talking about the first one I sent out, or it would have been the second
Yes.
one?
Well,
First
I'm
one,
not,
the first one or second one, either one of them.
the first one did not come back and got sent. The second one did get sent because the county clerk, when I went to get everything with them, took all the copies and wouldn't give it back, so I could mail it to her.
Okay. But she has had that at least 14 days before you finalized your divorce.
mm-mm.
Okay. Well, I know you say no, he says yes. But I've even, there's so many other questions on this thing. Because there's been so many opportunities to object and appear, and you didn't do any of that stuff. And I'm just trying to see why. Why would you not do that?
I've never received any of it.
Okay. All right. Mr. Wheeler, I got your motion relative to parenting time. Did you get a copy of that, Ms. Wheeler?
I did.
Okay. What's going on with parenting time, Mr. Wheeler?
Our daughter goes to school in the morning. My ex has an issue getting her there on time. She's currently missed 4 days since the start of the school year and had 7 tardies sent
No,
also.
That is wrong. I have the
Hang on a
paperwork.
second. Hang on. I think you might have missed the part, Ms. Wheeler, when I tried to tell everybody right at the beginning that you cannot interrupt people because it mutes out everybody's microphone. So I need you to just remain silent. I'll hear from Mr. Wheeler and then I'll hear from you. Okay?
Okay.
Go ahead. Mr.
And
Wheeler.
I have the dates they were missing, and I actually get the information from the parenting app that is linked to the school, so it gives me a calendar and what days and how many times she's missed or has been tardy.
All right.
And
Did the school voice concern? Did they say that this might cause her to be truant? Is it costing her? I mean, is the teachers saying, "Boy, but for this, she would be an A student, but because she's missing so much, she's not an A student." I mean, is there any of this stuff?
the school they sent text messages about that. One of them was like, hey, she's missed multiple days already, trying to see what was going on with it. And
Okay. Go ahead, Ms. Wheeler.
That is completely false. I have paperwork right here that she has missed absences of 3 days, and she's only had 4 tardies, and I've got the paperwork right in front of me.
Okay. Well,
And she's got good grades. She's above a 3.3 in her. She's exceeding expectations. She's proficient in mastery grade level content, approaching proficiency 2.5. Basic understanding, she has 2.0. And the only thing that she's struggling with is following directions.
thank you.
Mhm.
Well, I am going to at this time deny both motions. I need more than that, Mr. Wheeler, before I ever entertain doing something.
I can go get go make another motion, but have attached the
I need a lot.
School board.
I'm not telling you how to do your business. Okay. I would never do that. But I'm telling you that you need a lot more than just a 1-paragraph statement for me to do anything as far as parenting time when it involves school. You might want to start with teachers. You might want to start with the attendance officer, all those things. And I might consider it, but I'm denying the motions, both of them right now. So you're both all set with me. The judgment is going to stay and I'm not changing anything. But if you want to go ahead and do some due diligence on this, Mr. Wheeler, I'll entertain you bringing it back. Okay? You both are all set. Thank you.
Yeah, thank you.
Bye.
Good morning.
I've read this motion and in essence, I've heard this now. This is my third time, since February. Everybody's gonna say, it's not happening. Other people are gonna say it's happening. So, I've read everything. Anything you want to add, Ms. Gardner?
Yeah, the fact that I'm having to bring her to the hospital continuously because of situations like this, it's inhibiting my ability to actually stay at work. I had to leave work that Friday to go take her to the hospital, which, I mean, as her mother, yes, I should. I'm glad that my job was allowing me to do that, but that cuts into my money as well. And he knows that she has these allergies and continuously allows his mom to bring her over to her house, causing these issues to continuously happen.
Okay. Mr. Naninga, you got a copy of this motion, did you not?
Yes, I did.
Because I got a very detailed response, but not from you, but from your mother. Did you get that, Ms. Gardner?
No, I did not.
You didn't get a copy of this? Is pretty long,
No,
had pictures and all this stuff in it. Okay,
no, I have not.
all right. Well, do you know, Mr. Naninga, if your mother sent this to Miss Gardner too?
Yes, it was sent out on Tuesday at 3:05 p.m.
This Tuesday or last Tuesday? I'm sorry.
This Tuesday because I didn't get the motion till last Friday.
Right. And did you, Ms. Gardner, did you not, nothing came in the mail?
No.
Did it come back
I
to
can
you,
check my
Mr.
mail right
Naninga?
now real quick.
You can check the mail right now, but I'm a big stickler on everybody having everybody's stuff before I hear anything. And I don't like the fact that Ms. Gardner doesn't have what was written by your mom. That has to be remedied. So what I'm going to do is, Ms. Gardner, you can renotice this motion, postpone it, give you a chance, Mr. Naninga, to send your mother's response to Ms. Gardner. And then the next time we reconvene, we'll all have everything and put all our cards on the table. Because I will tell you this right now, I have some possible solutions. And one of them involves appointing a guardian ad litem for your child. And that's going to cost $5,000. And that will run $2,500 a piece for you and Mr. Naninga. That's one possibility. So I want you to read what Grandma says, and then renotice this out. You won't have to pay another fee. And I will see everybody when they come back, and everybody has everything else, and could use some more. Yes, I would like a letter from physician as to what exactly this is. Because I have found that these allergy things could be dogs, cats, other animals, dust, mites, all kinds of stuff. And we may have to rule out some of that stuff first, but I want to wait to see what you have to say about the response from Mr. Naninga's mother. Okay. So you know what to do?
Yeah.
Okay. But I'm just telling you both. If you can't come up with a logical explanation to this, I'm going to have to appoint a third-party attorney to look out for your daughter, and that's going to cost you both a lot of money. And I'm hoping to
Sir,
avoid
why would it be on me when I'm the one trying to keep her from being in these situations?
because the attorney only works for me and only represents your daughter, and it's on both of you. She's both your daughter, so you both pay it. But I'm not there yet. You wait till you get this response, and if you feel the need to bring it back after you get this response, I'll listen to it, and we'll see. But I'm just telling you that I have to break this log jam because I'm not going to keep going through this. This is now the third motion. February, August, now November. Third motion. Okay, so something's going on. But if people are looking for me to prohibit people from overnight parenting time, I generally don't do that unless I have something from a doctor that says, hey, look, this is all happening at this house and the child needs to stay away from that. I'm also a little concerned when I read an allegation that grandma has told the child not to say anything because that's problematic too. But that's what the attorney does. But yeah, Ms. Gardner, if this is going to cost you and Mr. Naninga money, okay? But I'm not there yet. I got to see what's going on, and I want some more information. So renotice this when you get this. Let Mr. Naninga know when you get a copy of his mother's statement, because I want you to read that in full. Okay?
Okay.
All right. Thank you both.